From Huruma, let's now go to those controversial security laws. If you remember, just about a week ago, the CORD team went to court and sought orders to suspend some clauses in the security laws, which they successfully did. And now the Attorney General, Professor Githu Muigai, has now again moved to the Court of Appeal, appealing the decision by Justice David Odunga to suspend 8 clauses in those controversial laws. The Attorney General has given 14 reasons rather for what he is appealing, for his appeal at that decision, and we are going to look at just 7 which we believe are the most crucial. Now, the first reason that the Attorney General has given is that the High Court had no jurisdiction to suspend those laws. He says that the learned judge erred in law and, in fact, in failing to find that the court had no jurisdiction to suspend legislation at this particular stage. The second reason given by the AG is that there was insufficient evidence to warrant suspension. He says that the judge erred in law and, in fact, again, in failing to appreciate that there was no sufficient evidence on the record to warrant the granting of the prayers of stay or suspension of the law. Let's move on. He says, this is the Attorney General, says that the judge should have waited for proof of unconstitutionality. Now, you know that in court or in law, if a person is found guilty, there is a law, there is a provision which says that you are not guilty. You are innocent until you're proven guilty. Again, in the constitutional law, a law is presumed to be constitutional until there is enough evidence which says that it is unconstitutional. Now, the AG says the judge should have waited until this law or these clauses were proven to be unconstitutional. Next reason, if the process was unconstitutional, why suspend only certain sections? He says the judge contradicted himself because the basis on which these security laws were suspended, the basis in which court went to court was that the whole process in which these laws were passed was unconstitutional. So the reasoning here being that if you're going to suspend some clauses, on the basis of those reasons given by court, then you should have suspended all the clauses, not just some of them. Let's move on. He says that the suspended provisions were not a danger to the Bill of Rights. Remember that the most contentious parts of these laws, some of the most contentious parts were that the laws were infringing on the Bill of Rights, but he says that those that were suspended did not infringe on the Bill of Rights. Now, the AG continues that the judge should have referred the matter to the Chief Justice, Dr. William Mutunga. He says that the learned judge of the High Court erred in law and in failing to refer the matter to the Honorable Chief Justice for the constitution of a bench to hear the applications for conservatory orders of stay or suspension of the law. Right. The very last issue here that the AG brings up is that the orders given breached the doctrine of separation of powers. That is something that we have come across several time and time over again, which is the separation of powers, and this is again between the judiciary and Parliament. And he says again, Nancy, that the judge erred in making because he did not again. He gave orders that were deemed to be in a breach of the doctrine of separation of powers. This saga is not about to end anytime soon.